Good morning, everybody. My name is Christopher Sontchi. I'm a United States Bankruptcy Court judge in the District of Delaware here in the United States, where it is very snowy, which we don't usually get, so happy to have it. Welcome to the Brexit aspects on insolvency and restructuring from the North American view. And we have a great panel here that's going to speak to you today. I'll introduce them shortly. But first, I'd like to turn it over to Mr. Mark Phillips, QC, who's going to give us some opening remarks.
Thank you very much, Judge. Good morning, everybody. In January of 2020, the UK left the EU and went into a transition period. During that period, the EU insolvency regulation and recast Brussels regulation continued to apply to the UK as if it were a member state. In other words, there was no change during the transition period. Negotiations came to an end last December, and we then turned to the 1,244-page Brexit deal. Many of us expected to see agreement that in some way continued the insolvency regulation and the Brussels regulation in substance or in effect, or alternatively, an agreement along the lines of the EU giving effect to UK insolvencies under UNCITRAL, since the United Kingdom was, and the United Kingdom continues to give effect to EU insolvencies under UNCITRAL, which the United Kingdom has incorporated through its cross-border insolvency regulations. But there was nothing. In the insolvency and restructuring fields, in the UK, we had what we call a hard Brexit. Amongst my colleagues in the world of international insolvency, the answer has always been clear. It is in the interests of all stakeholders in cross-border insolvencies to continue some form of recognition and cooperation. That had been the profession's focus since the early 1990s. And of course, the United Kingdom had played a central role in promoting the modified universalism on which it is based. However, what I thought was plainly right and not at all difficult hadn't even made it to the starting line. This is the second of 3 seminars organised by III, the ABI and the ABC. On the 18th of February, a panel considered the problem from a European perspective. And that discussion identified a number of difficulties resulting from Brexit, not least the point articulated by Mr. Justice Zaccaroli in his judgment a week ago in a case called Gate Group, in which he made it clear that if a scheme or arrangement will not be recognised somewhere that matters, the English court will not sanction it. The consensus during that seminar seemed to be that absent a political solution, for example, an agreement between the UK and the EU, that the EU will recognise UK insolvencies applying the UNCITRAL model law, which is a solution that's been articulated in articles, for example, by Professor Christoph Paulus, who I know absolutely everybody knows, that absent that, you would probably need 2 things, 2 locking schemes or arrangements. You need an English law scheme or process to compromise English law debt, and you would need an EU arrangement or process to secure recognition across Europe. Turning to North America, which is today's focus, Brexit raises the question of whether the EU remains a good springboard for North American insolvencies into Europe. Will North American practitioners look away from London for the European aspects of their restructurings? Will Brexit weaken London's status as a powerhouse for financial services? If London is unable to offer restructuring services that will be recognised with ease across the EU, why should businesses have English law debt capital structures? And is that an opportunity for New York? To understand the root of the problem, it is important to understand that the UK is now a third country, not a member state. In only 4 EU countries might UK insolvencies be recognised under the Untitled Model Law, and that is Greece, Poland, Romania and Slovenia. And you can see from that list the number of important jurisdictions that it is not. They are the only countries that have given effect to the model law. And the insolvency regulation does not apply to the UK, but it will be applied in the EU 27. And why that's important is that the EU insolvency regulation will continue to determine how member states deal with insolvencies falling within the scope of the regulation. The EU 27 would not recognise UK insolvency proceedings or determinations that are inconsistent with a determination of how a debtor's insolvency proceedings fall to be dealt with under the EU insolvency regulation. Now, whilst EU insolvencies continue to be recognised across the whole of Europe, of course, including being recognised in the UK under the model law, UK insolvencies no longer enjoy the same privilege. So we need to think, whose problem is this? Is it the EU's problem? Is it the UK's problem? Is it the problem of other jurisdictions who used to use the UK as a stepping stone into Europe? Or isn't it a problem at all? We have been thrown into an uncertain time and it was quite unexpected. Judge.
There we go. Sorry about that. Thank you very much, Mark. I was really struck when we were preparing this panel. When I was thinking of Brexit, I was thinking of, the UK. And I was thinking of North America. I was thinking of Canada, the Caymans, the US, and how they would deal with the UK. But it's very interesting to me, and as Mark identified, it's maybe more a question of how Brexit changes how we deal with Europe and the EU, maybe not as much as it changes how we deal with the UK, or the combination of Europe and the UK. And it was a factor that I had not, considered. This isn't obviously my field, but it's a factor that I had not considered. What we're going to do today is we're going to go through a series of questions. I'm going to open them up to our panelists, and they're going to talk about them. Hopefully they'll interrupt each other and keep this lively. And as well as we're opening the chat for questions. Now, we'll generally take questions at the end if we have time, but if there's something that I think is particularly interesting, I may interrupt the panelists with that question. So please feel free to post your questions on the chat. Before we get started, very quickly, I'd like to introduce our panelists. First, we have Caroline Moran. Caroline is a partner with the Maples Group in their Cayman Islands office. She's a highly regarded insolvency practitioner and has received numerous awards, including for her work on the Ocean Rig restructuring. Caroline attended University College Dublin and received an LLM from the London School of Economics and Corporate and Securities Law. We have Anup Sathy. Anup is a partner in the restructuring group of Kirkland and Ellis in their Chicago office. He is also a well-regarded insolvency lawyer, as are all our panelists, except for Alistair, because he's not a lawyer. It has been noted by Chambers USA to be a, quote, phenomenal lawyer, end quote, high praise indeed. He has worked on numerous significant restructuring, most recently on the Seadrill case, once again at this point in Houston, Texas. Anup attended the University of Illinois at Urban-Champaign and the second best law school in Chicago, Northwestern University. Denis Ferland is here as well. Denis is a member of the Davies firm in their Montreal office. Denis specializes in bankruptcy, insolvency, financial restructuring, and the related litigation. Near to my heart, he is also a teacher, serving as an instructor for the Chartered Insolvency and Restructuring the Chartered Insolvency and the Restructuring Professional Qualification Program. Denis serves as the Vice President of the Board of Directors of the Insolvency Institute of Canada. He attended Université Laval. And finally, Alistair Beveridge. Alistair is the Managing Director of the London office of AlixPartners. He has 3 decades experience in guiding companies through restructuring. He attended Strathclyde University and is a licensed insolvency practitioner, a fellow of the Institute of Chartered Accountants in England and Wales, and immediate past president of Insol Europe, a very distinguished panel. We're going to dive right in, and we'll start with the first question, which is a somewhat broad question. I think we'll drill down a little deeper and further in some of the sub-questions. But the first question to the panel is, to level set, how do restructuring proceedings involving foreign jurisdictions proceed in your jurisdiction? And how will Brexit change those proceedings, if at all? And may I turn it over to Caroline first, if I could.
Sure. Good morning, everybody. So restructuring proceedings in the Cayman Islands are typically North American or Asian rather than European facing. So we see Cayman Island schemes of arrangement of Cayman or foreign companies coupled with Chapter 15 or a parallel Asian process, or we would see a Cayman process in support of a Chapter 11. We tend not to see a huge amount of European-facing schemes run through the Cayman Islands. So I think on a day-to-day basis, Brexit is not going to have a very disruptive effect on our practice. Obviously, this question, like any restructuring, is case-specific. And I think what Brexit does is it puts England in the same bucket as those jurisdictions where you have to conduct a country-by-country specific analysis, and you can't rely on sort of broad recognition rules. So I think that's going to be a change that Cayman and US practitioners are going to have to deal with. I think one point, I'm going to mention this early on because I know it's an issue that's being debated before the Irish High Court today, is the question of the scope of Section 426 recognition in England under the Insolvency Act. I think this is going to be potentially a very interesting one for the Cayman Islands, and I think it's going to come into sharp focus in the coming months and year. This, for the benefit of the US audience, or those less familiar with the Insolvency Act, the Section 426 is the statutory provision in England which allows the English court to recognise foreign proceedings relating to insolvency law for certain designated countries. It stands outside the EU regulations, will continue post-Brexit. And it is quite a small list of designated countries, but Cayman Islands happens to be on it. And if a Cayman scheme, and it's a big if a Cayman scheme could be recognised under Section 426, then I think one view is that that would trump the rule in Gibbs, and the scheme would be recognised in England even if it was for English law governed debt. Now, the orthodox view is that schemes are not proceedings related to insolvency law for the purposes of Section 426, because in England, the schemes of arrangement provisions are in a different part of the Companies Act, and a company doesn't have to be insolvent to access them. That's the same in the Cayman Islands, but the current question that's before the Irish court today, in the Norwegian Air examinership, is whether a scheme within the context of an Irish examinership is an insolvency process for the purpose of Section 426 recognition. And the analysis is that the because a company has to be insolvent to enter into examinership, and because that's in a different part of the company's law in Ireland within the insolvency provisions, that should be capable of 426 recognition. In the Cayman Islands, while we don't have examinership, we do have the ability to obtain a moratorium for a scheme of arrangement process through a restructuring provisional liquidation wrapper. And the gateway to that is insolvency. So I think that is going to be a question that will be analysed in some detail as to whether a scheme in the Cayman Islands promoted through an insolvency wrapper is capable of 426 recognition. So I think just to round up, I'm conscious of speaking for a while. I think to round up, what we are going to see over the coming months is some creative thinking around how to deal with the Brexit problem, given that the European passport has been taken away from London. And I think we are going to see developments around recognition that are perhaps more creative than we've had to grapple with to date.
I think from the U.S. perspective, I think we start with a couple of premises. First is that our clients are global. All of our clients are global. And so there might be an instinct to say, it's not really our issue. We'll figure it out later, or they'll figure it out later, and then we'll know what the right answers are. But that's not how it's going to work. Our clients are multinational. They're global. They've got assets everywhere. They've got creditors are in different jurisdictions. And so being able to address these issues now and providing certainty to clients is really paramount. And so as we sort of watch from a distance, but not really, we kind of work with the premise that a number of these issues will get solved, that there are incredibly creative advisors and practitioners and courts and legislators that will try to fill the gaps here with respect to some of these really hard issues around recognition. I think that's sort of the long-term perspective that we have, that there will be answers, that this will get addressed, and there will be certainty. Our clients, our global clients, want certainty, and they want to know that if they're going to have a process, that it's going to work and they're not going to be surprised. I think that from the short-term perspective in the US, I think it may end up having a little bit more pressure put on the scope of our Chapter 15 cases. I think that's sort of what we think will be sort of the immediate impact, which is our Chapter 15 cases are intended to be ancillary proceedings to foreign proceedings. And the scope of the Chapter 15 orders and the scope of the application, I think, will be extended to the maximum extent possible. With respect to sort of our orders, our court orders, Judge Sontchi's orders, we sort of operate with a sort of a practical, what we call de facto recognition, that a U.S. court order is going to be honored, even if it's not technically honored in a particular jurisdiction, because the creditors themselves understand that they don't do well in the long term if they're violating U.S. court orders. And so we usually work through these processes by practically thinking about the jurisdictions and thinking about who the creditors are and where the assets might be, and then trying to develop strategies around whether you want to get multiple levels of recognition or basically rely on de facto. And what we expect we'll start to see is more application of Chapter 15 recognition into the broader areas of the worldwide assets and worldwide creditor bases of our companies. And we think that that's going to be, in many ways, sort of the filler until one of the fillers until what we expect will be a much broader solution to some of these issues related to recognition.
And if I may, if I look at how things happen in Canada, basically we have the CCAA that has adopted the Untitled Model Law. And it's the same thing in the US with the Chapter 15. And there's many, many cases that are conducted both in Canada and in the States. And I think it's a good example. Whether you have a CCAA in Canada and a 15 in the US, or an 11 in the US with a recognition in Canada as being the main proceeding, the Chapter 11 being the main proceeding, and it works very well. The courts have communicated with one another on a regular basis and rather freely. I even know of one instance where two judges, a Canadian one and an American one, sat in the same courtroom. They were the two flags in the same courtroom, the US and Canadian, but to me, it shows the collaboration between the two countries. And from a North American perspective, or at least for a Canadian perspective, but I think I can say from a North American perspective, that's how we see things and that's how we work. I mean, you can have two parallel proceedings, a CCAA in Canada and a Chapter 11 in the US. You then need a cross-border protocol. It's more complicated, it's more costly, and it encompasses a number of issues. So with this background, when we look at the rest of the world, I mean, it's almost tempting to go through the preamble of the Untitled Model Law, which seeks for cooperation, greater legal certainty, fair and efficient administration, protection and maximization of the value of debtors' asset, and facilitation of the rescue of financially troubled businesses. Once we've said that, if there are assets or entities in the UK and in the EU, how will that be dealt with? And the opposite is also true. If you have a UK entity that has operations or assets in Canada or in the US or in the EU, how will you deal with that? Will multiple proceedings with a cross-border protocol that will become a very complex and heavy structure and costly structure? Or will you try to find one jurisdiction and try to have that recognized in either the UK, Canada, or the EU? Because some countries in the EU do recognize or have adopted the model law. So will that mean that London and the English law that governs a number of contracts, will there be a shift to New York law? Does that mean that the Southern District of New York will be busier? It could very well be. And to answer one of Mark's comment of earlier, whose problem is it? At the end of the day, it's the client's problem. And the client doesn't want to suffer the uncertainty. So at the end of the day, we will need to find solutions. And if legislators do intervene, I think it will be very welcome.
So maybe I'll add a couple of comments there from a UK perspective, perhaps. I think one thing which we should be strongly aware of is that the level of practitioner and the level of experience in the UK is very, very strong. They've been very good at finding solutions to difficult problems and difficult situations with global clients. When Carolyn said earlier that the UK passport had been taken away, I think it's more like the UK passport was thrown away, which was pretty unhelpful. But I do think there's a potential for, as Anup said, solutions to be found for clients. It'll be very situation specific currently, but there does need to be a leveling up a bit on the basis that at the moment, EU insolvencies would be recognised in the UK, but UK insolvencies wouldn't necessarily be recognised going the other way. So it does strike me that there should be some desire to try and find a way in which that is leveled up so there is more of an even playing field. And one of the obvious areas which I think might become part of the discussion will be relating to the rule in Gibbs. Now, I'm not the lawyer here, and we could have a whole separate topic on Gibbs, but that's something which perhaps might seem like an anachronism to many people, and it's not entirely consistent with the way we approach compromising other legal documents subject to other jurisdictions. So that might be something that has to be given up in exchange for finding some other useful accommodations for the UK. But I've said I'm quite positive that there will be some solutions that are found. It's just, as Mark said, we're 2 months into the new regime, and as we sit here today, we haven't got any perfect solutions. But I think over time some will be developed. They might involve, as already stated, parallel proceedings. And I think the UK is probably inadvertently given a little bit more advantage to the US on its Chapter 11 side. It's probably also opened the door a bit to the Dutch, the new Dutch scheme, I don't know how you pronounce it, WOA. But both of those have benefits which we perhaps haven't got. So maybe part of the future will involve proceedings where there's a proceeding in the UK and there's a proceeding somewhere like the Netherlands. And why would anyone do that? Because it requires 2 proceedings and 2 complications. Well, potentially one of the reasons could be that even with 2 sets of proceedings and 2 sets of advisors in those 2 countries, it still might be slightly less expensive than Chapter 11. So from a corporate's perspective, even with the additional complication, it might actually be a sensible thing to consider.
Thank you. I think we're going to touch on Gibbs, not this question, but the next question, because in my mind, it might be a situation. I mean, it's obviously served the English courts very well over the decades. It actually might be a situation from a practical standpoint that it's in England's best interest, not as a legal matter, but as a practical, let's keep our business model moving, to abandon Gibbs. And that would allow, for example, to parallel proceedings in Europe and the UK, as opposed to just a UK proceeding with a recognition in Europe. And that runs into issues that only, I believe, 4 countries in Europe have adopted the model law on recognition. So very interesting issues. Let's just jump to a more specific question, generally along the lines of what we were just discussing, which is how are restructurings and insolvency proceedings from the US, Canada, and the Caymans recognized or given effect in EU countries? And sort of the subpart of that subpart is, have you been using England or the UK as a springboard to get the recognition in the US? Obviously, you do some sort of scheme in the UK, and then because of the European law, it gets recognized throughout Europe. And maybe we could start with Anup on this one.
Yeah, it kind of goes to the general theme we've been talking about, which is there has to be cooperation amongst the jurisdictions. There has to be some acknowledgement that the legal processes themselves have to effectively trail how our clients operate and how these businesses work. And so we have seen parallel proceedings more often in the recent years, and I do think that is related to Brexit, but just generally, I think the way that the processes are generally going. So, for example, we have a pre-pack admin going on right now in Valeris. Valeris is a PLC that is it was about $7 billion of debt. We commenced a Chapter 11, and we decided it made sense, just given the nature of the shareholder base, to do a pre-pack admin in the UK, and we did that because we wanted certainty, and our client wanted certainty with respect to the shareholders, and make sure that there wasn't going to be additional shareholder concerns. that's just one example. But what we have seen is that the frameworks that exist today are helpful for us to try to achieve the results. And we do think that from the Chapter 11 perspective and the US perspective, that moving our parallel proceedings and recognitions in other jurisdictions is a core part of the strategy. And we still believe that even though there might be a little bit of uncertainty today, that there's a real significant benefit in doing that.
And if I may, having proceedings recognized in Europe where the model law is not applied is a challenge. And very often when you have entities in Europe, you need to have a distinct filing in Europe. And there's not always a cross-border protocol. And the two process do not always align. So being able to use the UK is useful. If you cannot use the UK and you have to rely only on the local legislation of the countries that force a separate and distinct and autonomous filing, makes it more cumbersome and less predictable. And if the springboard of the UK is lost, I think it's a loss. And the next question is, should the EU adopt the model law? Because if it was to be the case, it would resolve a number of issues. But it's obviously a political issue that at least I have no control over.
I'm sorry, Caroline. If you're a jurisdiction that's acting solely in your self-interest to the extent of getting substantive insolvency proceedings in your country and all the positive economic effects that happen as a result of that, aren't you better off not adopting the model law? Because in my experience as a judge, Chapter 15's, I mean, that's a walk in the park. Sign some orders, a couple short hearings, as opposed to running a real restructuring.
Well, it's true that in terms of return, you're better off having a parallel proceeding. But if you look at it from the global perspective, and I think it's the way we must look at it, then if you need to have 2, 3, 4, 5 different parallel proceedings, to me, it makes no sense. So you need to have, I mean, the key word is comey. You need to have a main proceeding and being able to implement it in the other jurisdictions. Short of that, yes, the local bar will be happy, the local restructuring people will be happy, but the clients, I'm afraid, will walk away from those jurisdictions. So if you look at the number of financing instruments that are governed by either New York law or the UK, there's a huge amount of it. But if that becomes an issue, they will basically change the platform.
Yeah, I think it ultimately goes to stakeholder recoveries as well. I mean, if you have, we always say it's hard, it's expensive to go bankrupt, and what the concern is going to be that stakeholders and clients don't see a path if there isn't a clear way to implement in these global capital structures a restructuring that will stick. I mean, it's one thing to go through a process like this and then have it work. It's another thing to go through a process like this and then have it not work. And I do think there is a lot of concern about that. And ultimately, it may force fewer restructurings ultimately if people don't see a path, and that we don't think that's good for anybody. That's not good for industries if you have more liquidations and more sales. And so I do think that what will eventually happen will be this collaboration. I do fundamentally believe that we'll get back to that place, whether it's legislative or something else. But there is some short-term dislocation that may happen. And I do think that that may ultimately, in the short term, put more focus, Judge Sontchi, on Chapter 15s. And it may be harder. It may not be the couple of orders and walk in the park Chapter 15s anymore if representatives are trying to get the automatic stay extended maybe a little bit further than what you would have typically seen as a way to try to protect assets in other jurisdictions. And so I do think that we're going to have to come up with some more answers to these questions, even if they're short term for now.
All right, thank you, Anup. I'm going to turn to Caroline and then Alistair.
Thanks, Judge. Well, two comments. One, I have John Lennon's "Imagine" playing through my head after Denis's call to arms for the model law. But secondly, I don't think it's as bleak as all that, because really there are solutions, and there are currently solutions from the prospect of a global restructuring. So if you need European recognition and you're not confident that Chapter 11 is going to be sufficient, you can go to the Netherlands or Ireland or one of the other European countries and get your European passport. You're going to have the Gibbs problem if you've got English law governed debt in the structure, but that is just a scheme of arrangement in England. So yes, it adds potentially an additional layer of cost in that you have an additional process in England on top of what you have to do in Europe, as opposed to just carrying out one scheme in England. But that's not going to be significant, or not too significant, and it's certainly not going to mean that global restructurings are going to fall apart. I think this is more of a problem for England as a jurisdiction rather than other jurisdictions seeking to implement a global restructuring.
So I was going to say something slightly different, which was related to a point that Anup made earlier about Europe and trying to think about the different sort of proceedings that are available. You need to remember that there's the EU 27 other countries that aren't the UK. They've all got different ways of dealing with restructuring and ways of dealing with insolvency. And I think one of the reasons that people liked having the UK in the process was it was predictable. You knew what you were getting. There was a good bench of people. There was a very strong judiciary, predictability, certainty, and those are some of the things that have been lost. Now, that was a benefit for the UK, but actually it was a benefit for many of those other countries as well, because if they hadn't got a good judiciary or good systems or precedents, then even though they might like to do the restructuring in one of those countries, they actually couldn't, because they didn't have the tools themselves which actually would generate the outcome, which was the outcome that was required for the stakeholders and for the creditors. And I think that is where perhaps Ireland will certainly be looking to push its Irish scheme of arrangement as a tool and a passport, as will the Dutch. The Germans are obviously pushing their new law, but that seems to be very much domestic. And in any event, the EU was going through a process whereby it had asked each of the countries in the EU to come up with some pre-insolvency tools to help modernize the restructuring techniques that were used in Europe and bring them up to a kind of base level of usefulness. Most of those, apart from I think the Netherlands and Germany, who are ahead and have launched, most of the others are still in the works and not yet there. So there's still a lot of places in Europe where there isn't a predictable system. And so if we can find a way to use one of the other European jurisdictions as the base, and the Netherlands, I think, is my bet for the most likely one where that would be, then that potentially provides you with the solution. The other quick point I wanted to just make is that if you think about the types of cases, they fall into, in my mind, into probably two camps, and it's not as simple as this, but so I don't talk for ages, it might be easier if I look at it like this. One is financial restructurings, where basically the restructuring is of the debt burden and the trade and the employees and everyone else is kind of left whole. They're not touched, and it's the finance entities which are dealt with, and the debt obligations which are restructured. Those are often mostly set up for tax reasons with various structures, whether that be Cayman, or in Europe it might be double Dutch structure or Luxco's, which means that there may be a point in the structure where there's an ability to do something which doesn't involve the rest of the group and the rest of the structure, and therefore is less invasive, and therefore a little bit easier to deal with. The second bucket of situations are, I think, a lot less common, at least they are at the moment, despite what everyone might think, which is, insolvencies where companies actually file, they potentially go into liquidation, and the whole group kind of breaks up and falls to pieces. Those are the ones where, local laws are required, and coordination and lots of costs, and are to be avoided generally. But I think if we focus on the finance side of things, which is obviously where the English law and the rule of Gibbs comes into play, then I think there's more chance of being able to even have parallel proceedings, because the complications of 100 companies in 20 countries disappear, because it's probably then only linked to a small number of companies that are in the finance stack.
Thank you. I'm going to jump to a question from one of the panelists, and it's one of the attendees, and it's based on a proposition that I don't know is true or not. So, but I think the question is interesting. If a UK scheme is not an insolvency proceeding, and therefore not subject to the EU regulation, why does Brexit change the situation? The scheme was not automatically recognized in the EU pre-Brexit and is still not automatically recognized. And Mark, I want to throw that to you.
Thank you very much. Thank you very much. Yes, right. Press button for lower hand. Excellent. There are two things that you have to have in mind. First of all is the distinction which is now crystallizing between arrangements and reconstructions and schemes of arrangement. The Gate Group judgment by Mr. Justice Zaccaroli of a week or so ago actually considered why the new arrangements and reconstructions, which you find in Part 26A of the Companies Act, as opposed to schemes of arrangement, which are in Part 26, his reasoning was that they are insolvency proceedings, and therefore they do fall within would have fallen in the EU insolvency regulation if it had been introduced early enough that Schedule 1 would have been amended to include them in the list. So that's the first point. The second point is that schemes of arrangement, if they did not fall to be recognised, and I agree that they didn't, under the insolvency regulation, were being recognised under the recast Brussels regulation, because you were recognising the orders of the court, which were convening and then sanctioning the meetings, and the recast Brussels regulation is no more. As far as the UK is concerned. So that has gone as a result of Brexit. The UK applied back in April to accede to the Lugano Convention with the European Union. That application has not yet come to fruition. So at the moment, we are left with just the local domestic recognition procedures.
Thank you very much. Let me just jump to another question. We're going to kind of bebopping around this outline that we'll never get through. But let's just ask, if I could ask a very plain questions. Are UK restructurings less attractive now from a North American perspective than they were before Brexit? And I'll take any volunteers.
The one-word answer allowed.
Yeah, well, you sure, Alistair? One-word answer? Yes? No?
I think the answer is yes, they are less attractive. Unfortunately, I think that's right. Mark may have a different view, and so he no doubt put his hand up if he doesn't. But I think they are. Now, I don't think they're fatally wounded and they're a terrible outcome, but they're certainly slightly less attractive than they were. The good thing is that there are many professionals who understand those issues well. There are many financiers who've got English law debt, and I've also dealt with restructurings in the UK and understand it, and therefore I think people will be trying to find solutions, but for sure we've dented our position. Carolyn.
Yeah, I think to the extent you wanted to use England as a passport into Europe, I mean, that has just, as Alistair said, that's been thrown away. So if that was part of the rationale for using London, absolutely. The fact that that's gone, of course, because of the ruling Gibbs, doesn't mean that you can ignore England altogether if you've got English law debt in the structure. So I think for so long as there is English law debt, you are going to have to consider seriously whether or not you need an English process. And at the same time, I think, as you said earlier, we're going to start seeing more creative analysis as to how and whether you can get around the ruling Gibbs and avoid that additional process.
No, what's interesting is that the Parliament in the UK adopted the Corporate Insolvency and Governance Act of 2020, pursuant to which it abided by the requirements of the European Restrictive Directive. So the UK went forward and adopted what was required by the EU, and then Brexit occurred. The UK has a number of features for restructuring that have been used. I think the question mark is certainty and predictability if you have countries in the EU that are involved. And that's where, to me, the question mark is. And to add on Alistair's comment, I think that it sort of negatively impact the UK system. Having said this, coming to Briggs, I mean, I even read the judgment that dates, that goes back a few years ago. And if you're talking about financial instrument and the restructuring is limited to that, then that's easy. But if you go beyond the restructuring of the financial instrument, it gets more complicated. And that's where you may need, as Caroline was saying a second ago, parallel proceedings. And it goes to what was said earlier, it piles up the number of different filings and the cost and the complexities.
I look at it from the perspective of what our clients will want, and what they want is predictability, Denis, you make this, and stability and certainty. And so the UK will always provide those things, always. And so from my perspective, it does not significantly diminish. And to the extent that it does, I really do believe it's temporal. I believe in a relatively short period of time, the limitations that we have now been imposed, and whether it is now a gateway or not a gateway, and Gibbs, and whether it'll apply or not apply, I think we're going to find answers. And I think that the people, even on this panel and our guests, are going to be part of finding those solutions. And so we always see predictability in the UK process, and the predictability that comes with history and with advanced jurisprudence and judges and practitioners who understand these processes with the perspective of global clients and one of the financial capitals of the world. So there's no question that this is a step backward. I don't think anyone can debate that, but I do think that we will find answers, and we will continue to collaborate, whether it's through parallel proceedings or some other mechanism, to make sure that our clients get what they need.
All right. Well, I have one last question before before I look again to see if there are any attendee questions, but we've talked about whether it's bad for England, and we get a very positive yes from Alistair, and perhaps less strong answers from the rest of the panelists. Assuming it's bad for the UK, who's the winner? Is it the Dutch? Is it the Caymans? Is it the Americans? Is it the Canadians? Who wins or improves its position as a result of Brexit and insolvency proceedings?
Yep, I'll go first if you like.
Sure.
So I would say it's probably too early to tell. But I would say if I was ranking the winners, I'd say the US probably would be my first place. I'd say the Dutch would be my most likely second. And the reason that I wouldn't put them higher is only because their new process is new. Also, there's relatively few cases. There's not a lot of precedent. And it would take a relatively brave person to, send a multi-billion-dollar restructuring to that new process right now, where the predictability of outcome and the certainty is not as high as you might like. So that would be my view on where we've got to. I will just pick up one. There was one question in the chat that I thought might be worth answering, which is about new debt issuance. Do we think there'll be a law other than English law which might be used for debt issuance? And I think the answer to that is possibly yes, probably New York law. Given how easy it is to raise money at the moment, I think New York law bonds will make an even bigger surge into the European market this year and going forwards. I'll stop at that point.
Thank you, Alistair.
And picking up on Alistair's comment, if there's a winner, I believe it will be the Southern District of New York. And I do believe that New York law will be more appealing, at least on a short term, because eventually I cannot but conclude that a solution will be found either through case law or through new legislation, but the gap cannot remain forever. I suspect that the Southern District may be up.
I think the answer is quite somewhat nuanced in terms of I completely agree. If you're talking about a big, complicated global restructuring where you don't want to have to think too closely about the jurisdictional analysis across multiple different countries, Chapter 11 for sure, I think is the big winner. If you are looking at a restructuring where the passport into Europe is really important, I think Alistair is absolutely right to have Netherlands on the list. I think my vote will also go to Ireland. I think they're doing a good job at the moment in winning some significant restructurings. Plus it's got the proximity to London, it's got the same scheme of arrangement, and a lot of the English firms, I know many of those attorneys are actually now deliberately qualifying into Ireland. So I think that's one to watch. And then I think what's going to be interesting is that part of restructuring work where foreign companies were using an English scheme to compromise US law governed debt in lieu of using an all singing, all dancing Chapter 11. I think that potentially is business that England may lose out on, and we may see clients pushing. I think maybe that makes it lose its competitive edge somewhat because you don't get the benefit of the European passport. And on that level, England may find itself competing with the offshore jurisdictions, which also pitch for that work, including Cayman Islands, or with Ireland again.
Anup, if I could ask you to comment, I won't ask you whether Delaware or Texas will do better. I wouldn't put you in that position. And then we'll turn it over to Mark for some final words.
Okay, well, here's I have two observations. One, I think the winners and losers, it will almost all be intra-European. I think it's going to be a European-centric movement of the work and the centers of the restructuring community to the extent that there are winners and losers. I think, and I agree with Carolyn, on the margins, I do believe that if you're not able to find a nice, clean, clear answer, that Chapter 11 will provide that nice, clean, clear answer, but with all of the challenges of Chapter 11 and costs of Chapter 11 and the publicity of Chapter 11 and all of the things that come with that. And a lot of companies are not used to that. So within the framework of winners and losers, I believe that, and to the extent that documents now are turning into New York law, I think that is actually practically happening. But that's for that to actually manifest stuff into restructurings is not going to, it's going to be a while. So it's not like the new issuances are going to wind up in restructuring in 6 months. But I do think that within the European community, we'll see sort of movements away from London and toward other mainland European restructuring systems.
Thank you very much, and thank you to all the panelists. Mark, you want to send us home?
Gosh, thank you very much, Judge. And can I just say, speaking as an Englishman, it's absolutely fascinating to hear the North American take on a problem which has been discussed mostly amongst the Europeans. And that, for me, was extremely helpful. What have I taken from it? I think we can see that English restructurings have become less attractive, but I liked Alistair's description of it not fatal. And we must always remember that there is a lot of English law debt, and long may that survive for our particular branch of the profession. What I found particularly interesting, and it's one of the first times I've heard this articulated as a possibility, is the possibility of using either the US or Canada as a springboard for recognition of UK restructurings into Europe. And I think that's a really interesting variation, because most of the time we've been considering the damage that may or may not have been done to the UK as a springboard for American restructurings into Europe. So that's one that I think we can all take away and think about. Using Chapter 15 in the context of UK restructurings actually has not, well, not with me anyway, to my knowledge, been widely discussed. I think everybody agrees that we should cooperate. Everybody agrees clients need certainty. I think it was Anup used the phrase, "it must work," which is absolutely critical, and I'm sure that all the professionals recognize that. And I have to agree with the comments that, you know, we are in our profession right across the world. There are many, many very able practitioners, and I think that between us we will find answers. But the one thing that troubles me at the moment is that in order to find those answers, we need some tools. We need the tools that we can then use to come up with those answers. At the moment, I think I'm detecting 3 routes. The first I've already mentioned is the potential use of Chapter 15. The second is similar, was the potential use of Canada, but I defer to Denis entirely on how we would do that. And the other is the one that's been discussed quite a lot in the European markets, which is dual schemes, whereby you have a scheme or arrangement in England to deal with English law, and you have an interlocking scheme or arrangement in a European jurisdiction. And I'm not going to enter into a punch-up as to whether it should be Holland or Ireland in order to deal with recognition. But I want to finish, if I may, by just picking up the point that Kate Stevenson's made in the chat, which is, should we have a coordinated approach? And my answer to that is yes, absolutely. My personal view is that the solution articulated by Christoph Paulus in an article is the route forward, and that is for a UK-EU agreement whereby the EU will give effect to English to UK proceedings under an equivalent of the Untitled model law, in exchange for which the UK, England may have to soften the rule in Gibbs. And I don't put it any higher than soften. This is a huge political issue. The one thing that I'd say in relation to that is not happening anytime soon. We need a massive political wing to assist the insolvency to assist the insolvency restructuring market, and I do not see that myself. And I hope that everybody involved in this debate might encourage their own politicians to take this forward, because at the end of the day, this is something that the profession was working on since 1990 because it makes sense for stakeholders. It has got very little to do with national sovereignty. It is purely a way of making insolvency and restructuring work efficiently and certainly for stakeholders. And politics should rise above that, in my personal view. Judge, thank you.
Well, I am not talking about politics. That's a good way for me to get in trouble. Thank you very much, all of you, for a fantastic panel. I learned a ton about something, an issue I had not thought, I've certainly thought about Brexit for the last several years, not in this particular aspect and not in this particular, with this particular nuance. So I found it very helpful, and I expect our attendees did as well. Thank you, everybody, for participating, and I hope everyone has a great day.